liar. Everywhere. On netrootsradio.com. David Waldman. Kagro. In the morning. Now, here's David Waldman.
Hey, good morning, everybody. How you doing? It is Wednesday, August 2nd, 2023. Time for another show. I don't think there's anything happening, so I don't know. I mean, I guess we could do a show. We can make up some stuff and tell you that there's things going on, but I can't find any news no matter where I look. Of course, that's not true. Time for another show, yes. Time for another indictment. Well, actually, it probably is time for another indictment, but we had our indictment yesterday. Tuesday being the date set for a meeting of the grand jury in Washington, D.C., but no one was sure whether they were going to use their Tuesday meeting or their Thursday meeting to do this, or whether they'd even do this at all this week. But the news has broken, and there's no putting it back together again. Former president, quote-unquote president of the United States, Donald J. Trump, indicted again on the third time, which obviously is pretty unprecedented, like totally and completely. I mean, we haven't indicted any presidents, past or future for that matter, or present. He's been indicted 3 times. There's more to come. He'll be indicted in Georgia, no doubt, and certainly this indictment spells trouble for his Georgia state indictment. I don't see any way that they avoid that given what's alleged in this one. Greg Dworkin will be here because it's Wednesday, and because, of course, there's another indictment of Trump. This, too, they may pile on after this. We've seen the use of the superseding indictment in the Pervolago documents case already. It may be that there are plans to add charges to this. I'm not certain whether the superseding indictment thing in the documents case was a matter of, new things have come to light, or whether it was always planned that way and they just needed for certain cards to fall certain ways before they went ahead and launched it. It's pretty damning. I mean, really, it wouldn't be a bad idea to use the show, the entirety of the show, to simply read through the indictment. In most cases, it's not news to us in the sense that, all right, well, we've heard each of these stories discreetly before, and sometimes they've been woven together into a narrative, but this really lays things out rather nicely. And there are definitely a few things that I've seen people report. I haven't made it all the way through the indictment yet either. And it's a safe bet at this point that if you are just reading the digests of the material by the various reporters assigned to the beat, you're going to get a pretty complete picture of it. And they'll dig up all of these other nuggets. And along the way, I happened to see this one that was called out. And I don't know. Do we want to ruin it? Because I don't really think we're going to get a chance to just sit down and read through the whole thing. That would be a great Friday thing to do. But by that point, maybe you will have read it already. But I did see somebody using the social medias to make this point and call out a particular paragraph of what had been reported. And without getting too far into the commentary of it, we'll just show you the screen grab of paragraph 81 here, which I guess we could scroll down and find out which page it's on for you. But all the paragraphs are numbered, makes it easy. On the afternoon of January 3rd, co-conspirator 4, and there are 6 unindicted co-conspirators. We'll probably go over that list because it's pretty easy to imagine who most of them are. There's a little bit of fuzziness around 5 and 6. Could be several people. But anyway, co-conspirator 4 spoke with a deputy White House counsel, and I'm trying to remember offhand if co-conspirator 4 is maybe Jeffrey Clark, the description of the person. Not anymore. Oh, okay. I guess no more ambiguity, no more fuzziness. Yesterday evening, there was a little fuzziness. But I guess things have cleared up some. A co-defendant 5, I think, made sense to me, and it was pretty clearly identified with activities in Wisconsin. So it was either Ken Cheeseborough or Possibly. What's the other guy's name? Jim, dang, I can't even remember the guy's name offhand. Anyway, Greg will, Ken Cheeseborough is, because I think co-defendant or unindicted co-conspirator 5 was identified as the author of a particular memo. Number 6 is a guy by the name of Mike Royal. So we'll get to that when we speak with Greg in just a moment. Cheeseborough was the author of a particular memo that had been listed there. The recipient of that memo was who I was thinking might have been co-conspirator 5, but since authorship of the memo was the determinative factor there. But here I wanted to read you paragraph 81 because this one was actually news to me. I hadn't heard this allegation yet. On the afternoon of January 3rd, Mike Roman, sorry, not Mike Royal. Okay, well, Royal, Roman, what have you. On the afternoon of January 3rd, co-conspirator 4, who I think is Clark, did you tell me that already, spoke with a deputy White House counsel. The previous month, the deputy White House counsel had informed the defendant that, quote, there is no option in which you do not leave the White House on January 20th. Now, the same deputy White House counsel tried to dissuade co-conspirator 4 from assuming the role of acting, right? Where's my button here? Acting Attorney General. So that's Clark. That's the one he wanted to muscle himself in as Attorney General. The deputy White House counsel reiterated to co-conspirator 4 that there had not been outcome determinative fraud in the election, and that if the defendant remained in office nonetheless, there would be, quote, riots in every major city in the United States. Now here's the part that really grabbed me. Co-conspirator 4 responded, well, deputy White House counsel, that's why there's an Insurrection Act. Now, that's the conclusion of 81 here, paragraph 81. What this is saying here is that Jeffrey Clark said, in the face of riots in every major city in America, because Trump will have at that point obviously stolen the presidency and overthrown the legitimate government of the United States, in response to that, it was their intention to use the Insurrection Act to suppress the protest and to arrest and possibly shoot people who turned out in the street to protest Trump's illegal assumption and retention of power, which is an incredible thing to say out loud to anyone. And of course, I guess probably the ultimate example of how every Republican accusation is in fact a confession, right? They were accusing Democrats who hadn't done anything yet. They were accusing Democrats who might protest the coup, and this describes it in exactly those terms, who might protest the Trump coup as the ones actually mounting an insurrection. They were obviously at that point confessing, yes, we will be mounting an insurrection. I'm only saddened not to see Trump indicted on charges under the Insurrection Act directly. As I've mentioned a number of times, it seems like he went out of his way almost to deliberately violate the very arcane language of the Insurrection Act about whosoever sets on foot against the United States an insurrection. I mean, to actually tell people to march, literally tell them to set out on foot for the Capitol to launch this insurrection. They don't need it. They may come back to it. They may not want to touch it. It might be just fine for them to rely on these conspiracy and obstruction charges and fraud charges to defraud the United States, although that seems just so generalized. But I really do hope that they'll one day consider coming back with a superseding indictment, indicting him under the Insurrection Act. It couldn't be any clearer, if you ask me. And nor could it be any clearer that my duty at this point is to answer the fake telephone that we have on our fake radio. And welcome Greg Dworkin to the discussion. He probably can't wait to discuss the fact that yes, Donald Trump is a traitor and needs to be arrested, and I guess will be. Now we know he'll be arrested on these charges as well. So good morning, Greg. How are you?
Hi. So what do you want to talk about?
I don't know.
Anything happened?
There was a thing. There was a rocket launch yesterday, apparently, from.
Oh, there were big indictments yesterday. I don't know if you heard.
I hadn't heard.
Well, Matt DePerno, ex-Republican candidate for Attorney General in Michigan, as well as his buddy, GOP ex-state representative Daire Rendon, were facing criminal charges for alleged roles in an effort to access Michigan voting machines.
Wow. Access the Michigan.
That happened a couple hours before this other thing happened.
Yeah, I did. I saw those indictments, and I said, well, that's good news. I mean, once again, every accusation is a confession. Oh, they're violating, they're tampering with the voting machines, and if they're not, we will. And even if they are, we will, because we did already, and that's why we're accusing them of it.
Now, there'll be an election in 2024. I just want to point out that Michigan has done a wonderful job in cleaning up their mess with they don't have any money Republican Party, who apparently is following the directions of Donald Trump, whose PAC is spending all the money on legal fees, and they don't have any money either.
Well, good.
And then, of course, Georgia, even though there's a Republican in the governor's seat and Secretary of State, has done a pretty decent job of cleaning stuff up, and Fani Willis is still to come.
Yes.
But the huge news, of course, is that this indictment, which basically everybody weighing in is saying it may or may not be the easiest case to prove, only in relationship to the documents case, which is a slam dunk.
Yeah.
But it's by far the most important case. Gets to the heart of democracy and what Trump did and all that stuff. Now, the idea that you would take something that's a little bit difficult to prove, and I say a little bit difficult because you basically have to prove Trump knew he lost.
Yeah.
They can. They have evidence, and it's laid out in the document, in the indictment, but they still have to do it. They still have to convince a jury, all the members of the jury, that Trump knew he lost. And that's why David Frentz writes, it's a little bit more difficult to prove, but obviously more important. In fact, arguing from a point of law, which I can't, I'm not a lawyer. Some of the lawyers say, you know what, the documents case is stronger, but this case is more important. I don't know what stronger means. You know, one murder is more murderous than another murder. At the end of the day, you're dead.
Sure, no.
If he gets convicted, it's as strong as it needed to be, and no more and no less, and that's pretty darn strong. So we'll see. But in any case, of course, in the American system, you're presumed innocent until proven guilty. But in the court of opinion, he's clearly guilty. And everybody saw what happened on January 6th. So this happens. This indictment happens. And what's remarkable is not that it came, because we all saw it coming. We even sort of guessed what day it was going to happen. But at the same time, the response from the apologists and the enablers is still pretty remarkable. And, you know, Reverend Al had a statement about it today. You know, they all forgot the old song. If you want to go to the dance, you're going to have to pay the piper. They are totally tied to Trump at this point. They're simply incapable of getting away from it. And another point that I think was enormously underappreciated, made by Charlie Sykes today, is that, okay, you've got the documents case. You've got the New York hush money case. You've got this one, which may in some ways be the fastest of them because you don't have to deal with classified documents and the slowness in, having to review them and make sure everything is set up. And, of course, Jack Smith only indicted Trump, with the rest being co-conspirators, which we'll get to, which also speeds it up a little bit. And if you want to get an idea of why having more than one person on an indictment slows things down, look only to the Oath Keepers and Proud Boys trials.
Okay.
Where the same witness on any given day was examined and cross-examined by not only the government, but the other 72 lawyers for the other people who were also on trial at the same time. You know, it was endless.
Yes, okay.
And so that just delays and draws things out and makes it a 6-week, 6-month, 6-year trial, you know, whatever it's going to be. So streamlining it is a good idea. Anyway, all of that stuff happens, but Charlie Sykes makes the point that whether you're talking about this trial or that trial, from now until the election, the news is going to be dominated by, here's a Trump indictment. Trump is being accused of a rapist. Trump is being accused of hush money. Trump is being accused of insurrection. Trump is being accused of falsely retaining classified documents that he wasn't entitled to. The zone, Charlie said, is going to be flooded with Trump's a crook news, and you can't get away from it.
Yeah.
And so the Republican strategy for the election was Hunter Biden, maybe inflation. Look over here, we got this other shiny thing you want to follow. News media is not going to follow that. They're going to be flooded with Trump's a crook stuff, and that's what the coverage is going to be 24/7 from now until the election.
Yes.
And if you think that has no effect, that penetrates bubbles. That penetrates even, I don't want to listen to politics stuff. It just gets out there. It's just too overwhelming.
Yeah, well, it's late night comedian fodder.
Yeah.
As trial goes on and as they pull goofier and dumber stunts trying to get out from underneath these charges. And of course, it's more than Trump's accused of, because the plan originally was, well, we'll just accuse Biden of everything. But this is, Trump is currently on trial for.
And, you know, like in the case with the Georgia poll workers,
yeah,
courts will make people like Rudy Giuliani attest to a fact under oath that, what I said wasn't really true.
Yeah. And
that's going to be news to their advantage. And if you say, okay, well, you know, I'll just tune out the national news. Let me go local. I'll just pay attention to state news.
Yeah.
Matt DePerno, ex-representative Daire Rendon, charged in Michigan voting machine. You can't get away with this stuff, and you can't get away from this stuff.
All right.
It's going to be at state level as well in the swing states, because the swing states are where the action happened. So Charlie Sykes is absolutely right. This is a zone flooding event, and therefore it's a campaign-changing event. I don't care what the polls say right now.
Well, good. Buy stock in tar and or feathers.
Right. So let's look at some of the specifics, because that's the overall.
Oh, all right.
And when you look at the indictment, again, listening to the apologists and the enablers, they basically had three defenses. Defense number one is, look, this is all First Amendment stuff. The president is entitled to say whatever he wants. You can't indict him and convict him on that. It's a free country.
Wrong. What else?
Well, it is wrong because, in effect, you want the quick summary. He's not being indicted because of what he said. He's being indicted for what he did.
Yeah.
So this is all about acts, not speech. And in fact, paragraph 3 at the very beginning, page 2, the defendant had a right, like every American, says the indictment, to speak publicly about the election and even to claim falsely that there had been outcome determinative fraud during the election that he'd won. He also was entitled to formally challenge the results through lawful and appropriate means, such as seeking recounts or audits of the popular vote in states, or filing lawsuits challenging ballots and procedures. And as an aside, he did all those things. He lost every time. Indeed, in many cases, the defendant did pursue these methods. His efforts to change the outcome in any state through recounts, audits, or legal challenges were uniformly unsuccessful. That's because in a court of law, you have to go by facts, and the facts didn't support him.
Yeah.
So, that's number one. Number two is they'll use the excuse of, well, I was misled by my lawyers. Well, half of your lawyers that misled you are co-conspirators.
Yes, and the other half are the ones saying, no, there's no evidence, don't do this.
Right. So that's not really going to work.
No.
It's just not really a credible defense. And then the third part is, well, it's the George Costanza defense. He really believed that he had won, and therefore, there's no criminality here. That won't work because Jack Smith has the goods, which he lays out clearly in the indictment. And that is, as the New York Times has a story about, a testimony to the work the January 6th committee did, because they gathered all of the, I told him he lost stuff. Mm-hmm. And in fact, Jack Smith used it. So before the break, let's just spend some time going over the co-conspirators.
All right.
Co-conspirator number one, an attorney who was willing to spread knowingly false claims and pursue strategies as the defendant's 2020 re-election campaign attorneys would not. Exactly what you just said.
Yes.
They were told they didn't do it. And further down, it's pretty clear who that is. And that is going to turn out to be Rudy Giuliani. Yes. Couldn't happen to a nicer co-conspirator. And I think all of them are going to be charged. And maybe they already have been and it's sealed. We don't know.
That could be. That's
but
true.
Separating Trump out for speed and then getting these guys later, fine.
Yeah.
Co-conspirator number 2, an attorney who devised and attempted to implement a strategy to leverage the vice president's ceremonial role overseeing the certification proceeding to obstruct the certification of the presidential election. And again, with further information later down, that's John Eastman.
Yes.
Okay. Co-conspirator number 3, an attorney whose unfounded claims of election fraud the defendant privately acknowledged to others sounded crazy.
We know who that is.
We know who that is. You know, that's clearly Sidney Powell. Who
Yeah.
Everybody thought was crazy, including the people on the Trump side.
Although I am reminded that, Lynn Wood is still floating around out there, but okay. I mean, he was also crazy, but I think, Sidney Powell. Okay.
But he didn't have a national
no.
Role the way that Sidney Powell. He wasn't in the office, I don't think.
No, I don't think he shows up at the White House the way she does.
And again, January 6th documents, people saying she's nuts.
Mm-hmm. Yeah. Well,
my favorite here
is.
Because he's been so obnoxious and unrepentant, is co-conspirator number 4, a Justice Department official who worked on civil matters and who, with the defendant, attempted to use the Justice Department to open sham election crime investigations and influence state legislators with knowingly false claims of election fraud. And that Justice Department official, of course, is Jeffrey Clark.
Yes. Good.
The guy who tried to instill himself as acting attorney general, and everybody else telling Trump, you do this, we all quit.
Yep.
That was a big deal. Co-conspirator number 5, an attorney who assisted in devising and attempting to implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding. That's Ken Cheeseborough. And we know that because later on they talk about a conference call that he was on with some of the other conspirators.
Yeah, the reason I thought for a moment, the guy I was thinking of was Jim Trupis, and he also is this is also all about the Wisconsin angle on this, and he was heavily involved in it, and is discussed in other narratives, not the indictment, as being the essentially the ringleader of the effort in Wisconsin to round up and use the fake electors, and but there is a mention in the indictment of a memo written by co-conspirator number 5. Cheeseborough is, in fact, the author of that memo. The recipient of the memo was Jim Trupis. So, I mean, they're closely connected here, but...
sure, they're all connected because they all talk to each other, but the question is who did what and who initiated what, and do you have it on paper you can prove it?
Right. Both of the names are in the header of that memo. It's just, okay, well, I see. He's not the writer, he's the recipient. Okay, well, then that's Cheeseborough.
Yeah.
Okay.
Then co-conspirator number 6, which was the mystery co-conspirator nobody could figure out, a political consultant who helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceedings.
Yeah, it seems like they have a dozen of those.
Right, but Mark Thompson makes a case that it's Mike Roman. Listen to this, which is paragraph 61 in the indictment.
Yeah, hello, I'm Mike Roman and I'm guilty. Oh, okay.
Well, he actually tweeted a picture of a Philadelphia Eagles number 6 jersey. So, yeah, just what you said.
Pretty much. Okay.
To manage the plan in Pennsylvania on December 12th, co-conspirator 1.
Rudy, yeah.
Okay, Rudy. Co-conspirator 5, Cheeseborough, and co-conspirator 6 participated in a conference call organized by the defendant's campaign with the defendant's electors in that state, Pennsylvania.
All right.
When the defendant's electors expressed concern about signing certificates representing themselves as legitimate electors, co-conspirator 1, Rudy, falsely assured them that their certificates would be used only if the defendant succeeded in litigation. Subsequently, co-conspirator 6 circulated proposed conditional language to that effect.
Okay.
Now we go to the January 6th committee.
All right.
Okay, let's pull up Exhibit 13. This transcript reads, while you're pulling it up, I'll represent it to you. This is a December 12th, 2020 email that you wrote to Josh Finley and Mike Roman, as well as others, regarding alternate elector coordination. And you wrote, quote, Mike Roman and I were on a conference call with Mayor Giuliani today.
There's one.
Right? So that's Cheeseboro. So they're talking to Cheeseboro. You wrote, Mike Roman and I were on a conference call with co-conspirator number 1, and the mayor indicated he'd like to wait until all the electors have voted before pulling out any statements or otherwise alerting anybody to focus on making sure the vote gets done and minimize the chance of electors being harassed. What can you tell us about the conference call involving you, Cheeseboro, Mike Roman, and Mayor Giuliani? Yeah. And Cheeseboro said, I would invoke the Fifth Amendment.
All right.
But that's the call.
Okay.
And that's the call that's referenced in the indictment. It's Mike Roman.
All right. Well, sure. Why not?
I'm not smart enough to figure this out. Marcy Wheeler and a couple other people did. But, I was thinking, maybe just because he has such a big mouth, it's Peter Navarro. Maybe it's Boris Epstein. Who were the? It's not Bannon and it's not Stone. It would be obvious if that were the case. But who would be involved enough so that we sort of would at least recognize the name, a political operative, having read all the stuff about what was going down over the months before this indictment. But it turns out, if you're going to go to the text and you're going to relate it to stuff that the January 6th committee did, again, emphasizing how important the January 6th committee was to this indictment, it's Mike Roman.
Okay. Well, I think that's pretty conclusive about it. There are an awful lot of people. Anybody who was an attorney, they named as
by the way,
attorney.
Before the break, let me just mention Mike Roman used to work for the Koch brothers before he was a Trump staffer, before he was doing this. So that's how he gets involved.
Bound for prison one way or another. Okay, good.
Hi, I'm Scott Anderson, the guy that writes the daily summary for this show, Kagro in the Morning. Thank you to everyone that supports this show. Many of you send donations through PayPal, Patreon, Square Cash, Radio Public, and so on. Some of you write your own essays and send them in, or read articles with your own commentary. We appreciate it. Now, some of you are listening to this and thinking, I'd like to help, but isn't there something I could do that wouldn't require money or effort? Why, yes, there is. You can just like us. On Daily Kos, they call it the recommend button. YouTube has a thumbs up. There are hearts and likes and love buttons. Tap our love button. Tap our love button every day. Share our shows and summaries on Facebook and Twitter, YouTube and iTunes, Stitcher and Amazon. Most of these places allow you to write a review, so a sentence or two would be great. Recommend us to social media, or tell your friends to listen to the show. You aren't just helping us, you're helping them find their new favorite thing to listen to. You could change the world. So thank you in advance from me and everybody else in the world.
All right, welcome back now to the Kagro in the Morning Show here on Unindicted Co-Conspirator Radio. Everybody's an unindicted co-conspirator, really, at this point. Okay, so I think we've unraveled things there, and we have a pretty good idea of who's not currently named for whatever reason, and it may be because, well it's because they didn't indict them in this thing, but you may look for additional indictments later on.
Those guys will be indicted, I'm sure.
You have to be pretty spectacularly in deep in order to make it into these mentions. It's impossible. Sometimes they throw somebody in just because they're necessary for the narrative, even if they don't intend to indict them, but there really isn't anybody on that list.
And that's what's so fascinating. Let's talk about those guys next.
Okay. This list is short enough that you could pretty much expect every one of them will be, maybe Mike Roman, whatever, not necessary to bring criminal charges.
Well, see, but if you're going to have a conspiracy and you have a phone call where all the conspirators were talking about the conspiracy, how do you not indict all of them?
I mean, it may be that's a guy that you indict, and I will probably never end up at trial with this guy. He'll just plead, but who knows?
That's right.
But there are more, and then, all right, where were you going with this? We were going to say
the people who weren't indicted.
Okay.
Who weren't
named,
in fact,
or
mentioned in this document, sometimes copiously and deeply.
Yeah.
who are going to be star witnesses at this trial.
Okay.
Mark Meadows and Mike Pence.
Hey, Mike Pence, that guy is so upstanding and everything. All right.
Well, let me tell you a few things about Mike Pence. First of all, anticipating what's going on here.
Yeah.
Here's a statement from Mike Pence last night, which differs from, let's say, what a Kevin McCarthy or a Hugh Hewitt or, pick your apologist might say.
All right.
Today's indictment, said Mike Pence, serves as an important reminder anyone who puts himself over the Constitution should never be president of the United States. That's a pretty strong statement.
For him, it certainly is.
He didn't add, and by the way, I'll vote for him if he's a nominee.
He means it.
It's not clear.
What did the fly say?
But he said it.
Yeah. Yeah, that's a thing. Right, so now he and Chris Christie can hang out outside the debate.
Yeah, well, they can debate each other's. I don't really care. So, again, the indictment then goes state by state with some very, very good detail. I'm not going to go into all of that detail. DePerno's not mentioned in the Michigan statement, and I'm not sure. Let's see. I'm looking at if they mention co-conspirators 6 in the section, but they don't. They go over Wisconsin, and they go and talk about clearly a document written by Ken Cheersborough. They mention Ronna McDaniel and how the RNC was involved, but she is not a co-conspirator.
Well, not one of the,
They do a lot about Jeffrey Clark and about
good.
how that's important, so I thought that was really good.
Yeah, he's the worst.
Right? The thing I'm looking for, here it is. Section 93, paragraph 93, page 34.
All right.
This is perhaps, you mentioned the part about Jeffrey Clark saying, we'll just send the Army.
81. Right, so you're on 93. I got to get up there.
And that's, by the way, for those of us who are Nixon-Watergate era, Kent State, don't think they wouldn't do it.
Yeah, right.
So hugely important. But 93, and it's just a very brief note here that I'll highlight. During the meeting, as reflected in the vice president's contemporaneous notes,
yes,
the defendant made knowingly false claims of election fraud, including, bottom line, won every state by hundred thousands of votes. We won every state. And asked regarding a claim a senior Justice Department officials previously had told him was false, but about 205,000 votes more in Pennsylvania than voters.
Yeah.
Okay. But, okay, fine. They're talking about whether or not Trump knowingly knew he lost. During the meeting, as reflected in the vice president's contemporaneous notes, they have the vice president's contemporaneous notes.
Yes. That's, of course.
That's huge.
Yeah.
That means he's going to be on the stand.
And that means he turned them over to
yes.
them voluntarily, presumably.
So whether it's Mark Short or whether it's Pence, Pence gave him the notes. Now, how does Pence run for president with this?
Yes.
Well, he won't be, because I don't even think he's going to make the debate stage.
I guess not, though he should, because he's got something
to say. Well, he make his
but
points, he's going to have to withdraw, especially after this. He's going to be a witness.
Yeah. Well, okay. That's interesting,
Mark Meadows
too.
was not indicted, but, with all the stuff Cassidy Hutchinson did with the January 6th committee, how is Mark Meadows not indicted?
Yeah.
Well, that's because he flipped.
Maybe, or certainly he's not needed for this narrative, which is incredible, too, by the way, that all of this should be documented, and you don't even need the purported White House chief of staff involved in this in order to tell this story. That's pretty incredible.
But here
obviously he is
the
involved
vice president's chief of staff later on saying that he was so concerned about Trump's threatening Pence that the day before the insurrection, the chief of staff was moved to tell the Secret Service Pence might be in danger.
Yes.
That's in here.
Okay.
I don't have it right in front of me, but that's in here.
Well, yeah, that's something that we've heard before, but it's astonishing to see reiterated. But we know that we know very well, I think, the story that Pence refused to get in the car at the Secret Service behest.
Yes, but let me just step back a little bit and remind myself and everybody else. It's one thing to read about it in a New York Times story.
Yes.
And it's another thing to read about it in a court of law indictment in which the prosecutor is effectively saying to the judge and the jury eventually that I'm not only making this allegation, and it is just an allegation, he's innocent until proven guilty, but I could prove it. Yeah. Because if I couldn't prove it, it wouldn't be in here.
That's true. Although, sometimes people screw up, but that in combination with, this means that they intend to tell a court and offer witnesses and other proofs, a story that says, one, they were prepared to respond to protests among Americans at large with the Insurrection Act and put it down by force. And at the same time, they were also possibly willing to threaten the life and safety of the Vice President of the United States in case he said, hey, maybe this isn't right. They were going to bulldoze and possibly kill everybody who stood in their way. That's an astonishing story. Yeah. Don't forget about that. And it looked like it would have worked if you had gotten a body there. I don't know whether you could have gotten the people who thought they were going to hang people to go through with it, but somebody in a mob would have accomplished that purpose, certainly.
Paragraph 104, beginning at 11:56 a.m. on the day of the insurrection, and this is Trump speaking. The defendant made multiple knowingly false statements integral to his criminal plans to defeat the federal government function, obstruct the certification, and interfere with others' right to vote and have their votes counted, which is, of course, what he's being indicted for.
Yes.
But the statement, the defendant made multiple knowingly false statements integral to his criminal plans.
Yes.
Means Jack Smith is making this allegation and he plans on proving it in a court of law to a jury.
Well, all he really needs to do there is run the videotape of the speech from C-SPAN.
So the concept and the idea that, well, this is really a difficult case because Jack Smith's going to have to do those things. The means to do those things are all right there.
Yes. Well, there they are. And he'll be doing it in front of a D.C. jury. So, it's not an Alabama jury.
So that's what I took away from the indictment. And that's not a detailed reading of every line. I'll leave that for experts like Marcy Wheeler. But when I read it, that's what I get. I get a sense that Smith thinks he can prove what he's saying. He put it down. It's, if the apologists are going to argue First Amendment rights, Smith covered that.
Yes.
If they're going to argue that, well, my lawyers told me this and I just believe my lawyers, you got right here that the other half of the lawyers said, no way.
Yeah, that's okay. Not helpful.
And if you're going to argue, well, he's George Costanza and it's not really a lie if you believe it, well, here's all these people telling him it was a lie.
Yeah.
He was told. If he didn't want to listen, there was actually a guy on Fox and Friends this morning.
Yeah.
Saying,
really? There's a guy there?
Look, this is relatively simple. If you're going to argue that he really believed it, let me put it this way. He gave this example. Let's say I claim that I'm Elon Musk's long-lost son, and I'm entitled to his millions or billions or whatever he's worth.
That's a good idea. You should do that.
Well, you could say that.
Yes.
This actually, you haven't broken the law if you claim that. On the other hand, if you go to court with papers trying to get his money, that's a crime.
True.
So it's not what you say, it's what you do. That's what he told the Fox News audience.
All right. Yes. I happen to think that it's probably part of the reason why it was so important to identify everybody in the indictment who was a lawyer as a lawyer. It's particularly egregious for you to arrive in court with those papers if you either do it as an attorney or, acting as an attorney in the case, or somebody who happens to be an attorney in the background, but you're just party to the case. You will have reason to know that it's especially egregious for you to agree to file this paperwork.
Hence, co-conspirator number 2.
Yeah.
John Eastman's in big trouble.
Yeah.
He's going to lose his academic appointments. He's going to lose his law license, and he may lose his freedom.
That's, and it's amazing because I'm sure he thought he was safe in all this, not only because I imagine he might have thought that they might be able to pull this off, but he certainly probably thought this is just aggressive, zealous representation of a client. It's all protected speech, whether it turns out to be that the theory is right or wrong. But this is what happens when you really push to the extremes on the pre-wrong theory. I can just get judges to agree that my interpretation of things is right and your 200-year-old understanding of things is wrong. But I guess when you're rolling the dice on what is essentially an insurrection against the United States, you have to win that one, or else it all falls apart. You go to jail. You can't rely just on the pre-wrong thing, unless you have the judges sewn up. And, I think 60 losses in court should have been a pretty clear indicator that you don't have things sewn up with the judges, guys.
Right. So, and again, Eric Hirschman told Jeff Clark, you better get yourself a good criminal attorney.
Yeah, because you're not.
And Gregory Jacob, who was the counsel to the vice president, told John Eastman, you're nuts.
Yeah.
This is garbage.
It is.
And
it's hard to
testified
differentiate
under oath to the January 6th committee that, and I got Eastman at the end of this conversation to admit that, okay, it'd be against the law to do that.
Yeah.
But he did it anyway.
Yeah, because I'm sure they were still operating under the assumption of, well, it's currently against the law. Yeah. But I don't know that I'm going to, you're going to be able to prove that.
Rewrite law, and besides, I'll be pardoned if Trump is reelected. And
there's a big difference, though, just qualitatively between pushing that line that, you're all pre-wrong when it's about, regulatory law or even criminal law, but not where it involves you, where you're the defendant. It's awfully hard to use the pre-wrong thing when you're the defendant in all of this. It becomes pretty clear. Like as they say, the jails are full of innocent people, who've been framed for their crimes. Nobody's guilty all of a sudden. Well, right. Yeah, everyone tends to look with a more jaundiced eye at criminal defendants saying, well, you just don't understand the law. The truth is that the founders meant that it was okay for me to do this because of who I am and how awesome I am, and the rest of you it's illegal for. That tends to be poorly received.
So I'm, reading the apologists and saying, well, it's in D.C., and so probably they'll convict him. But it's a really weak case legally. And I'm thinking, you know what you're talking about. Actually, you do. You're just paid to not know what you're talking about.
Yeah, okay. But, it is true that D.C. is not a great place for him to go on trial. That's true, and that's because there's, normal people there who believe real things.
Yeah, he also got a judge who was not Aileen Cannon, who actually is not real keen on, violent overthrow of the government she represents.
Mm-hmm. Okay.
She's given some pretty harsh sentences to the January 6 people on trial before her.
Well, what is she, tough
Everybody
on crime
in
or
D.C. is
something?
now experienced with this January 6 stuff because they've all had cases.
Yeah, and it's, it's a sensitive local issue. It happened here.
Right. So I'm going to turn to a really interesting article by David French in the New York Times. Again, conservative.
French, yeah. But French.
But, it makes some interesting points. He himself is an attorney, if I'm not mistaken.
Yes.
In the weeks after the 2020 election, the legal system was in a defensive crouch, repelling an onslaught of patently frivolous claims designed to reverse the election results. Next, prosecutors pursued the organizers of Trumpist right-wing militias, Proud Boys, and Oath Keepers who had engaged in a seditious conspiracy to keep Trump in the White House. Now, as you pointed out at the very beginning of the show, Smith didn't go for that. He basically kept it simple.
Mm-hmm.
Smith is pursuing Trump himself, French writes, alleging criminal schemes that reach the highest level of American government. That's the case that, if successful, can once and for all strip Trump of any pretense of good faith or goodwill. But make no mistake, the outcome is uncertain for exactly the reason it's important. So very much of the case depends upon Trump's state of mind. again, we went over a lot of the people who are going to be testifying that they can testify to a state of mind and what they told them. At the risk of oversimplifying an indictment that contains 4 distinct counts: conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an official proceeding, so those 2 counts are about the same event. They're all about the same event, really. A conspiracy against rights, which is to say the rights of you, the voter, which is, I guess, a reference to a Ku Klux Klan law, the first Ku Klux Klan that U.S. Grant got passed. It can be broken down into 2 indispensable components. First, it'll be necessary to prove what Trump knew, and that's what all these people kind of testified that they knew, they told him, et cetera, et cetera. And therefore, if you didn't know, it was willful blindness. Second, it'll be necessary to prove what he did. And again, I don't know that that's all that difficult.
Right.
So he says, for example, 18 U.S.C. Section 371, conspiracy to defraud the United States. The statute is designed to criminalize any interference by deceit, craft, or trickery. There's little doubt that Trump conspired to interfere with or obstruct the transfer of power, but to prevail, the government has to prove he possessed an intent to defraud or make false statements. Well, that's where all those co-conspirators come in.
Yeah.
With each state by state. This is what happened in here. This has happened there. This is what happened there. And by the way, after the fact, the people that were claiming that there was fraud in places like Michigan are indicted.
Mm-hmm.
In other words, if you were to urge a government official to overturn election results, French writes, based on good faith belief that serious fraud had altered the results, you wouldn't be violating the law. You'd be exercising your First Amendment rights. That's where this First Amendment argument comes from for conservatives.
Yeah.
And he acknowledges, French does, that the indictment recognizes the constitutional issues, that the prosecutors correctly state Trump had a right, like every American, to speak publicly about this. So the prosecution has to prove that Trump knew he lost.
Yes.
Well, and that's precisely why the case is so important. More important than any previous Trump indictment. If the prosecution prevails, it will only be because it presented proof beyond a reasonable doubt that the election fraud claims that a substantial percentage of the American people still believe to be true were not only false, but were known to be false when they were made. French then goes on to say, and so that's what's really so important about this. He's not so naive as to think he's going to change the 37% who are MAGA of the Republican Party. They're not going to change their minds. But the 37% who are persuadable, this referring to the New York Times poll the other day, it matters to them. If they can prove that they've been lied to, if they, the government, can prove that they, the persuadable Republican voters, have been lied to, then in the end it may make a difference.
Yes.
So that's why he's so keen on this. This case is no slam dunk. I agree with Renato Mariotti, who stated that it's not as strong as the federal documents case against Trump, but that's only because the Mar-a-Lago documents case is exceptionally strong.
Yes, and just as a procedural reminder, remember, don't get confused. It'll happen. But for all of this discussion of, well, they can prove Trump's state of mind and what he really thought in this one. Remember that in the Mar-a-Lago documents case, that doesn't actually matter.
And in this case, it may not either. It's what he did.
Yes, that's
right.
True.
I don't know whether or not I believed everything, but I do know I organized a conspiracy to put fraudulent electors in various states.
It's just that in the documents, it doesn't matter why you have them or what you believed about them. If you had them, the end.
Right, and it doesn't matter why you obstructed.
They will talk about that.
You obstructed.
Yes. Yeah, I mean that's an interesting way of showing it too, right? The state of mind stuff goes to defeating the First Amendment claims.
Right. So French goes on to write, if a prosecutor believes, as Smith appears to, that he can prove Trump knew his claims were false and engineered a series of schemes to cajole, coerce, deceive, and defraud in order to preserve his place in the White House, it would be a travesty of justice not to file charges. I go back to the Raffensperger call.
Okay. Yeah.
I'm not asking you for a clean count. I'm not asking you for an accurate count. I'm just asking you to find this number of votes because that's what we need to win.
Right. And then he farted. It's just true.
That may or may not be admissible.
I didn't see that, by the way, in the indictment, and I'm a little disappointed.
Yeah.
That's
Consider
really
some of the
egregious
claims in the case. Paragraph 66 says Trump directed fraudulent electors to convene sham proceedings, et cetera. You got to prove all that stuff. And that's the tip of the iceberg. Millions of Americans believe today that Biden stole the presidency. This is where French, diverges from what the courts really need to do to politically what he wants. Mm-hmm. Millions of Americans believe today that Joe Biden stole the presidency. They believe a series of demonstrable, provable lies. There's no sure way to shake their convictions, but the judicial system can expose his claims to scrutiny, and that scrutiny has a potential to change these minds that are open to the truth. Smith has brought a difficult but necessary case. Foot soldiers of the Trump movement are in prison. Its allied militia leaders are facing justice. And now the architect of our national chaos will face his day in court. And this is the trial America needs, which is the title of his piece. It's an interesting look at it. I think Smith, again, like most of these prosecutors, probably has more evidence than he put in the indictment. You're not required to give you every single piece of evidence. Eventually, you'll have to share that with the defense.
Yeah, it's not disclosure. It's just indictment.
Yeah. So that being the case, you have all these people who the public record says told Trump all this stuff. So it doesn't seem to me to be all that difficult to prove to a jury. They're lay people like me.
Yeah. You believe it, so okay.
Well, I saw what I saw. I heard what the January 6th committee had to say. How could you not believe it? I think they'll convince a jury. It's very convincing.
Oh, I think so. Yeah, right. So
that's why some of the conservative commenters, National Review and all that other garbage. Well, it's not a very strong case, but they'll probably win. Well, what the heck is your definition of a strong case?
Yeah, I mean, it's not a very strong case, but they'll probably win. You mean they'll?
It wasn't a really strong murder.
Yeah.
But, the guy's probably dead.
They'll probably win means they'll probably prove beyond a reasonable doubt that they're right. Oh, well, that's not very strong. No, that is very strong.
You know what the subtext is here?
We're wrong.
It's a ridiculous trial to bring, and, Trump's not guilty, but they're going to do it in front of a black jury, so he's going to be convicted.
Oh, okay, yeah. Right.
This trial and all trials like it, said Ron DeSantis, ought to be moved out of D.C. How could you get a fair trial in D.C.? What is he saying? He's saying I don't want to be tried in front of a black audience.
Yes.
A black jury. That's what he's saying.
Right. And, I mean, here too, this is somebody else that if we were going to indict him, I would note he's an attorney and we should charge him that way. That you bring people to trial in the venue where they committed the crime. There's just no way around it. It's bedrock constitutional
And a jury
stuff.
of your peers convicts you, not Joe Biden, not Joe Biden's Department of Justice.
Right. And not
they just do the indictment
either. Right.
And the DOJ is independent anyway, but they don't convict. A jury of your peers convicts you.
Yeah.
That's the American system. You don't like it?
He has no peers. Yeah. Right. Or just find a way to prove that everybody's wrong about the jury of the peers, et cetera, et cetera. We just think it's different.
Right.
Well, so far they're 0 for 60 or 1 for 61, I think, in court.
Yeah, they got the one case where they said, okay, some of the ballots in Pennsylvania that were sent in by mail can't be counted or can't be counted early. I forget even what it was. It was immaterial.
Yes.
That's the one case
immaterial to the outcome. Yes. And so there's still room for superseding indictment to indict him for the Georgia recorded fart. I think that's going to happen.
Well, there'll be superseding indictments for those co-conspirators, I think.
Yes.
And then the final
they
thing
won't
to mention is this
one.
very nice short New York Times article. Trump's indictment follows a roadmap created by the House January 6th committee.
Well.
Now, one name I haven't seen come up today, who I'm sorry, I know you don't like it, but I have to bring it up. Mm-hmm. Liz Cheney deserves a lot of credit.
That's all right. She
wasn't the only one on the committee. There were a whole lot of other committee and a lot of committee staffers who did a great job.
Yes.
And they absolutely ought to be celebrating today because their work led to this.
Yes.
But Liz Cheney's part of that.
Sure. That's
fine. She lost her job over it. Right. She was courageous the way that Rusty Bowers in Arizona was courageous, the way to a certain extent Brad Raffensperger in Georgia was courageous. Yes, the Republicans. And I left this for last because so many other people have made this point. Mm-hmm. But when you go through the list of people testifying that they did the right thing, like Rusty Bowers, or they told Trump the right thing, they're all Republicans. The star witnesses, Mark Meadows and
he wasn't great.
Mike Pence, are Republicans. This is a Republican indictment by a Republican special prosecutor.
That's true too. Yes, that's all true. That you don't want to vote for them, but they did a good job.
Not necessarily. I wouldn't vote for Liz Cheney, except if she were running against a Trump enabler.
Yeah, I guess so.
But that's not the point. The point is they did the right thing and they deserve credit for it.
Yes.
And this is a scathing indictment that was set up by attestations by Trump loyalists and Republicans.
Yeah.
So, the idea that this is a Democratic, created sham indictment is just, BS.
That's true.
And by the way, you left out one of the best lines of the whole thing.
Oh. What was that?
Complaining about the nonsense that was coming down from everybody.
Yeah.
That they were sending all sorts of crap down from the mothership.
Oh.
When they mentioned that,
Yes.
we lost. We were 0 for 32, and it's pretty easy to see why. Again, I don't have that statement right in front of me, so I'm paraphrasing. But we lost 0 to 32. You could see why. They were sending all that crap down from the mothership.
Yes, right. And they used
Except they didn't
a
use
naughty
that.
word. Right.
Well, I was going to save you the horn because I didn't know if you had it ready. That's bullshit.
That's
But that was a great
basically
line.
Yeah, that was pretty good. The mothership, that's a funny invocation all by itself. Yeah, so okay, point well taken. Lots of decent things and even courageous things done by Republicans. That doesn't mean that Republicans are courageous people or that they're a good party. Individual effort on the part of what Republicans regard as bad apples who now need to be kicked out of the party. So there you go. Is there room for them in politics in the future? I don't know. We'll see. It's particularly ironic for the Cheney family that built its original dynasty on being on the other side of that equation. But, well, okay. Point well taken. Liz Cheney, poor you. But thanks for doing it, and glad you took it upon yourself. Okay. We'll see you on Thursday. It's not even Thursday already, so we'll see you tomorrow.
See you tomorrow.
All right, welcome back now to the Kagro in the Morning Show here on Netroots Radio. Well, we were a little late with the outro music, so things are a little screwy. It's going to create a editing nightmare later on, but you didn't miss anything. I think we got all the substantive stuff in before our hard break for that 1 minute. And let's say, honestly, it really would be not a terrible use of time to really comb through the indictment at this point. But I want to add a couple of additional points of view about it, other things that I picked up along the way and saw people say. One, I should acknowledge, I think, a good one, a good line here on Mastodon from DAT, David Allen Green. I don't know what the T is for, but David Allen Green has this to say: a future historian tasked with working from contemporaneous sources what witch hunt meant in 2023 would likely conclude that it meant a slow, methodical, and evidence-based process with full due process rights used to prosecute someone with significant political and media power. Of course, Donald Trump, calling the whole thing a witch hunt, and then things laid out in such glaring detail in the indictment such that he's unlikely to be able to escape conviction on these charges. And labeling it a witch hunt, well, here's what the evidence says a witch hunt apparently is totally different from what he probably imagined. Anyway, I thought that was a good point. Also out there and worth sharing, I put aside how Daily Kos, in many cases, on the front page, treated the indictments, and I thought this was an interesting angle on things. I really kind of do. Maybe we will parse through the indictment a little bit more. Maybe we should read it in reverse, although it probably won't make as much sense as a narrative. But since we know most of the points, just to see what is in the paragraphs at the end that we haven't gotten to yet. But anyway, Joan McCarter, who was with us yesterday and hinted at this being an important point, and has indeed made that point with this post from yesterday asking in the headline, does Mitch McConnell still think that Trump is, quote, liable for everything he did while he was in office? Remember that this essentially is all based on the excuses that McConnell and certain other Republicans gave for not dealing with the problem directly when they had it in front of them and it was in their hands, i.e. in Trump's second impeachment trial. There were Republicans who insisted that Trump is in the wrong here. He probably should be removed from office, but he will be removed from office in a matter of days here, or I guess by the time the voting came around to it, he had already been removed from office. And so the proper outcome here wasn't to impeach a president who had already left office, although they wanted to claim that that was not legally possible and not a viable option. It of course has legal precedent. We all know about that. And then they went ahead and just showed everybody that, yes, you can do it because we're doing it right now. But remember that they were going to seek to avoid voting to convict him and therefore barring him or being offered the opportunity anyway in the penalty phase of barring him from federal office in the future. This would have solved a lot of problems, by the way. And I mean, everybody urged them to do exactly that, but they were frightened and they didn't do it. So McConnell and others offered the excuse of, well, this isn't the right venue to decide that. He needs to be put on trial for these things and let a judge and jury decide whether or not he's really guilty of these things, not us political actors. Well, of course, now the time has come for a judge and jury to hear the evidence and make that decision. And it's the official position of Trump world and MAGA world that this is all a travesty of justice. And so you people who we will threaten to hang if you disagree with us, what do you think about whether or not this should be a matter to be decided at trial by a judge and jury? And, the trend has been for Republicans to, discreetly, at the moment of impeachment, disagree that impeachment was the proper venue and to instead push this onto the courts. And now that it's the court's turn to take a shot at this, the duty of the elected Republican is to say, no, the courts are the wrong venue for this. Yes, but you said they were the right venue. Well, that was when the current venue was impeachment, and I didn't want to do that. At that point, I used the courts as an excuse to not do my job as the court of impeachment. But now that the court of law has it, and though it's not my job to execute the law in court for them, politically speaking, no, I oppose this as well. So there's, in other words, and it ends up being the case that Republicans generally will say there should be no accountability whatsoever for any of this, except for the few of them who said, oh, there should absolutely be accountability, and then got kicked out of the party. So now the question is, does McConnell stand by the dodge that he used to not vote to convict Trump at impeachment time? Or has he shifted his ground now that it's in the hands of the courts? And I don't know yet because I haven't read it yet, but my guess is that he hasn't said too much, but that when he does say it, it will be, no, there should probably be no accountability at this point either. Although he does sometimes surprise us. And if he's never going to run for re-election again, who knows what he's going to say. But Joan poses the question. Republican Senate leader Mitch McConnell voted not to convict Donald Trump during his second impeachment, and his first one. The one prompted, of course, by endangering the lives of all members of Congress and trying to overthrow the government. Despite his no vote, McConnell had some pretty tough words. There's no question, he said after emerging from his shell, none, that President Trump is practically and morally responsible for provoking the events of the day, McConnell said. He has since, not had much to say about those things. The leader of the free world cannot spend weeks thundering that shadowy forces are stealing our country and then feign surprise when people believe him and do reckless things, which is 100% in the spirit of the indictment, of course. Anyway, he was voting against impeachment, but not letting Trump off the hook, he suggested, because there were still legal remedies. President Trump is still liable for everything he did while he was in office and as an ordinary citizen. Okay, and there's some actual audio of him saying this if you want to hear what his voice sounds like. Anyway, unless the statute of limitations is run, still liable for everything he did while he was in office. Didn't get away with anything yet. We have a criminal justice system in this country. We have civil litigation. This is criminal, of course. And former presidents are not immune from being held accountable by either one. So, we should expect a statement from McConnell shortly, congratulating the Justice Department for holding Trump accountable, right? Well, I don't know. It's just left there. And of course, the implication is that we're not going to get such a statement. Though again, he could surprise us because I think he's pretty much done running for office and, probably won't care a great deal about coming under MAGA attack at this point. But, on the other hand, it's a hassle. Why take that hassle on just to do what? To convince people that you're kind of sort of normal? To what end? To run for re-election again? Oh yeah, we're not doing that. So I don't know. It could cut either way. I guess we'll wait and see. Also of interest, just because of what it is, front page, Daily Kos coverage, Hunter drew the assignment on reporting the actual indictments, and I guess we got about as close to a banner headline as Daily Kos ever offers us. I mean, I assume you could do some tinkering with it and get a larger font to use for headlines, but, who knows what systems it might wreck. So instead, they went with all caps in order to emphasize that this was a banner headline. Trump indicted again. I'm not sure how he covered it here, but it's well illustrated with a horrible, ugly picture of Donald Trump. They're all horrible, ugly pictures, but this one is particularly gruesome looking. And it was basically a running live update sort of thing, which presents in reverse chronological order now. So we'll read it the other way. Quick hit that they put up just to get something on the front page was the grand jury investigating Donald Trump's attempts to nullify his 2020 presidential election loss has now indicted him on 4 counts. You know what the counts are. Trump already faces multiple other indictments. Jack Smith indicted him for the documents. All the charges pending against him. And it was just a hit, and I guess Hunter drew the short straw on putting that thing up just so people could comment on it. The updates, I'm interested in seeing how things developed along the way. So let's see, about 5:41 p.m. Eastern yesterday, the indictment cites 3 criminal conspiracies. You know what they are from having combed through the indictment. Let's see. Does he dig anything else up? I guess he's really just reading through the document and then saying, oh, this is something. Let's throw those up there. First, he, in a few minutes after the initial update, he's guessing at Rudy Giuliani and John Eastman being unindicted co-conspirators 1 and 2. Then Trump Chief of Staff Mark Meadows does not appear as one of the 6 unnamed co-conspirators, which will only add to Trump camp speculation that Meadows turned on him to provide evidence to the grand jury. He wrote a few minutes later. Let's see. Yeah, I don't think there's anything in here that we didn't get to in the discussion with Greg. So that frees us up at this point to, let's see. Is this, this might be of interest. I don't think we called this one out. This, I think maybe his last update, this from about just before 7 p.m. last night. The indictment really is just full of little details to show Trump's contempt for both truth and law. And a quote here, on January 1st, the defendant called the vice president and berated him because he had learned that the vice president had opposed a lawsuit seeking a judicial decision that at the certification, the vice president had the authority to reject or return votes to the states under the Constitution. The vice president responded that he thought there was no constitutional basis for such authority, and that it was improper. In response, the defendant told the vice president, quote, "You're too honest." That's really remarkable. So they're a good call to single that one out. Interesting, too, just by the way, I mean, in the certainly the least important point to take from this particular paragraph is it's of some interest to me. As Hunter says, you know, it really is full of little details that shows Trump's contempt for both truth and law. This one, in the end, shows the contempt for truth. But by the way, an additional contempt for the law, the fact that they are filing a lawsuit seeking a judicial decision that at certification, which hasn't happened yet, that the vice president has the authority to reject or return votes. This is an advisory opinion and something that the Article 3 federal courts are forbidden from rendering. You have to have an actual case or controversy. There has to be damages. You really basically have to wait until the deed is done. And if Pence were to say, I find that I do not have this power, Trump could have presumably at least attempted and would have been on better grounds saying, I've been injured here. There's been, you know, you can't use the courts to intercede to prevent some harm from coming to you with the narrow exception of restraining orders where you're able to show, one, that you will suffer some horrible and irreversible harm. And I mean, if you're talking about overturning an election and changing things, I don't know how irreversible it is if you can make your point. And two, you have to show a substantial likelihood of succeeding on the merits of your case, and that was never going to happen. So there was no restraining order avenue open to him. He was just looking for an advisory opinion from the courts. Tell them what we think the law means is really true, and that's just not something courts can do. That itself is, it's not a particularly egregious contempt for the law, but it's just contempt for, hey, this is how things work. You're not really allowed to do this. I don't care that you're not allowed to do it. Do it. And if the courts aren't going to entertain it, fine. Let them rule against me. But in the meantime, file this damn case. And nobody ever stops and explains these things to Trump. This is not the only such example. He's constantly asking for these things. He just did it in seeking to have Fani Willis dismissed from the cases in Georgia and to block any indictments from being handed up that might have come from the grand jury because of her bias that he alleges, which is something that you have to, you got to go through the process and then appeal the process. You can't file suit ahead of time and say, change the process. That's not a thing that Article 3 courts do. It's not a thing that most state courts will do. Some state courts will, don't have a prohibition against advisory opinions, I guess, in the state constitutions. But there is one in the federal constitution, and he continuously ignores that. And it's part of the reason he loses all the time. He just mounts or artificially boosts the number of losses that he's going to have to suffer by continuing to do this. Anyway, not the most important point, but, a subtle point that I felt needed to be added. Also in the Daily Kos coverage, they run the AP article that gives you a breakdown of Jack Smith's case. Now, we've had plenty of breakdowns of this case already, and I'm wondering whether we wouldn't just be best served spending the rest of the day kind of combing through it. And maybe you too have been reluctant to just sit down and read the whole thing, hoping that somebody else would do it, essentially. And I can't blame you on that front. But I have a couple copies. Everybody was distributing copies of the indictment itself, and Greg had used one that was offered up by the New York Times as an annotated indictment. And to some extent, the annotations are of some use. And I guess where that's the case, we can pause and look at it. But let's see. I think we can probably skip over the first couple of paragraphs, or at least skim through them, because they tell you things you already know. I mean, the indictment or sometimes it's worth reading an indictment in full just to see what kind of language. How do you structure something like this? What does it look like to charge the president of the United States or the former president with this, or charge anybody? How do you convince a court that, you're serious and this is a charge that you need to have a trial on? Because you can't just show up and say, he's totally wrong, Your Honor. Let's do the law things. It goes like this. For instance, it has to start that the grand jury charges that at all times material to this indictment, on or about the dates and at the approximate times stated below, the following things happened. Section here of introduction. Like, for instance, 1, the defendant, Donald J. Trump, was the 45th president of the United States, and as a candidate for re-election in 2020, the defendant lost the 2020 presidential election. Paragraph 2, despite having lost, the defendant was determined to remain in power. So, for more than 2 months following Election Day on November 3rd, 2020, the defendant spread lies that there had been outcome determinative fraud in the election and that he had actually won. These claims were false, and the defendant knew that they were false. But the defendant repeatedly and widely disseminated them anyway, to make his knowingly false claims appear legitimate, create an intense national atmosphere of mistrust and anger, and erode public faith in the administration of the election. Next paragraph, number 3, the defendant had a right, like every American, this is the First Amendment stuff, to speak publicly about the election and even to claim falsely that there had been outcome determinative fraud during the election and that he had won. He was also entitled to formally challenge the results of the election through lawful and appropriate means, such as by seeking recounts or audits of the popular vote in states or filing lawsuits challenging ballots and procedures. Indeed, in many cases, the defendant did pursue these methods of contesting the election results. His efforts to change the outcome in any state through recounts, audits, or legal challenges were uniformly unsuccessful. And that's the case. Now, one of the sort of notations here, one of the first is Charlie Savage on this paragraph saying, here, the indictment acknowledges that Trump had a First Amendment right to lie about the election and to file lawsuits challenging its results. It seeks to draw a clear line, though, between those kinds of lawful efforts and the unlawful means of discounting legitimate votes and subverting the election results that are the focus of the criminal case. True, and there you have it. So, paragraph 4, shortly after Election Day, the defendant also pursued unlawful means of discounting legitimate votes and subverting the election results. In so doing, the defendant perpetrated 3 criminal conspiracies. And again, as a reminder, they are A conspiracy to defraud the United States using dishonesty, fraud, and deceit to impair, obstruct, and defeat the lawful federal government function by which the results of the presidential election are collected, counted, and certified by the federal government in violation of 18 U.S. Code Section 371. B, a conspiracy to corruptly obstruct and impede the January 6th congressional proceeding, at which the collected results of the presidential election are counted and certified, that is, the certification proceeding, in violation of 18 U.S. Code Section 1512K. And C, a conspiracy against the right to vote and to have one's vote counted in violation of 18 U.S. Code Section 241. Each of these conspiracies, which built on widespread mistrust the defendant was creating through pervasive and destabilizing lies about election fraud, targeted a bedrock function of the United States federal government, the nation's process of collecting, counting, and certifying the results of the presidential election, i.e., the federal government function. That's what's at stake here. You've obstructed a federal government function. Number 5, the allegations contained in paragraphs 1 through 4 of this indictment are re-alleged and fully incorporated here by reference. Next up, the conspiracy. From on or about November 14th, 2020, through on or about January 20th, 2021, in the District of Columbia and elsewhere, the defendant, Donald J. Trump, and it's then set apart and centered and bolded, the name Donald J. Trump, set apart from all of the paragraph number 6 here, did knowingly combine, conspire, confederate, and agree with co-conspirators known and unknown to the grand jury to defraud the United States by using dishonesty, fraud, and deceit to impair, obstruct, and defeat the lawful federal government function, aforementioned, by which the results of the presidential election are collected, counted, and certified by the federal government. The purpose of the conspiracy, paragraph 7, says the purpose of the conspiracy was to overturn the legitimate results of the 2020 presidential election by using knowingly false claims of election fraud to obstruct the federal government function by which those results are collected, counted, and certified. The defendant's co-conspirators begin listing here in paragraph 8. The defendant enlisted co-conspirators to assist him in his criminal efforts to overturn the legitimate results of the 2020 presidential election and retain power. Now, among these were, and they're listed in subparagraphs here, A through F. They are co-conspirators 1 through 6. We've already described who they were and given you the names that probably correspond. So we move down to paragraph 9 here, the federal government function, which keeps getting referred to as, that's the phrase they're using. What function is it? It's the collection, counting, collection, certification of electoral votes. The federal government function, by which the results of the election for president of the United States are collected, counted, and certified, was established through, the Constitution and the Electoral Count Act, ECA, right? A federal law enacted in 1887. The Constitution provided that individuals called electors select the president and that each state determine for itself how to appoint the electors apportioned to it. This glosses over and elides past another point that they were soundly defeated on in court. The idea, this is where they tried to leverage the independent state legislature theory for different purposes than the Supreme Court actually just recently addressed it. But this was where they hoped that they could convince state legislatures that they could, after the fact, after they had decided we will apportion our electors based on having an election and giving the electors to the winner of the popular vote in that state, mostly. Some states divide it in certain ways, but that it would be the popular vote in the state, the franchise would be exercised by the voters of the state in order to determine how the electors will be apportioned. And the Republicans and the president and his co-conspirators here were all in the business of trying to convince state legislatures in key swing states controlled by Republicans that you can basically just say, no, we call for a do-over. And not only a do-over, but not really a do-over. We're not going to have the election again. And then, but we'll trust the second one or anything like that. No. There wasn't going to be an election. There was just going to be the legislature saying, to hell with the election. Yes, we decided in front of everybody that we would have an election to determine how we would apportion our electoral votes, but we didn't like the outcome. And we say that from now on, by diktat, that the electoral votes will be apportioned this way. And they claimed in court that this was a constitutional right of each of the states, that the independent state legislatures had the right to determine how those electors would be apportioned. And that part is true, but they ignore the part where they already did that. They were just basically arguing that state legislatures are so powerful that they can, with impunity and unreviewably, decide to take a second bite at any apple they don't think tasted right the first time. That you can hold a popular election and then throw out the results and just substitute your own preferences later on. And that's incredible and wrong. But it's a place where they could have just, insisted that the rest of the country was pre-wrong. And if they had gotten judges to go along, we all would have been stuck with that one, I guess. And maybe where the Republicans even draw the line on this stuff is, I guess, if it inures to your personal benefit. I mean, when it's a policy dispute, they don't seem to be terribly bothered by this, we'll just show everybody that they're pre-wrong kind of approach to things. But when it's a personal power grab. I don't know why they differentiate, because it's often a personal power grab to just change the policy. But I don't know. Maybe that makes some difference to people like the Cheneys in some way. They feel some kind of weird honor system should govern. I don't know. Anyway, we're coming up on our third break here, and I don't want to miss the timing on the music this time. So we'll just read a little bit extra of paragraph 9 over the outro music here. It was, of course, that the Constitution provided that individuals called electors select the president, and each state determines for itself how to do it. Through state laws, each of the 50 states and the District of Columbia chose, and it's all over now because they chose already, to select their electors based on the popular vote in the state. After Election Day, the ECA required each state to formally determine or ascertain the electors who would represent the state. Hi everybody, it's me, David Waldman. Yes, the same guy who interrupts you all the time. Interrupting you one more time just to tell you again, another reminder that your contributions are what keep this show on the air, and patreon.com, patreon.com, is still among the easiest ways to make the sustaining subscription donations that keep us afloat. Are you ready for the pep talk about how our Patreon campaign is still going strong and growing? Well, too bad. Yeah, the plain fact is we actually are headed in the wrong direction, and whereas we once had about 175 monthly patrons, we're now actually down below 150. Time to recruit some more. Not exactly the kind of news I wanted to share, but there it is. For those of you in a position to support the show, patreon.com does make it easy to make those secure, recurring monthly contributions to do so. Patreon.com/KagroX gets you straight to our donation page. We've been through a lot together. The worst of the pandemic, we hope. The worst of the insurrection, we hope. So go ahead and treat yourself. You don't need an excuse. Give yourself the gift of a little something you enjoy in life. Support the show. And of course, if you happen to prefer using PayPal or even the Square Cash app, we're up and running on those options too. So thanks again, everyone, for all your support. We couldn't, or at least shouldn't, do it without you. Hope you'll be on board soon too. Thanks for all your support. All right, welcome back now to the Kagro in the Morning Show here on Netroots Radio. Yes, I know. I'm debating the wisdom of this whole thing, but it's a pretty serious indictment, and we really better understand it and really better see every part of it. And who knows what sort of conversation will spark along the way. But we were in the middle of paragraph 9 of this thing, and we'll try and speed up the reading a little bit here. But again, after Election Day, the Electoral Count Act required each state to formally determine or ascertain, that's an important term, the electors who would represent the state's voters by casting electoral votes on behalf of the candidate who had won the popular vote, and required the executive of each state to certify to the federal government the identities of those electors. It's a very formal process. Process nerds are really going to love this. Yeah, you won the election. They said so on TV. How do we translate that into your presidency? The electors of the winner of the popular vote meet, and they meet in each state, and you say, I'm the elector that's supposed to be the guy, and the state officials who are supposed to do this neutrally say, yes, everybody knows that Joe Biden won Arizona. You were the named electors. And remember, on Election Day, very often in some states, those names are on the ballot along with the name of the candidate you're voting for. These are the people who would be the electors from Arizona should this candidate win. Here they are. And that way, when they show up on, December 14th or something like that, they show up at the state capitol as required by law and cast their votes, then they can say, well, just to be sure, you're not an imposter, right? What's your name? Show me your ID. Oh, yeah, that's the name of the guy who appeared on the ballot and everything. Right, sure. And then the governor or whatever state authority says once they've cast their votes, 1, these are the people who were supposed to be the electors as named by the candidates themselves and who in some cases their names appeared on the ballot. They have proven to me that they are those people with correct identification or however else we choose to validate that. And these are the documents that they signed indicating that their votes were cast for Joe Biden. This is our copy of it. We are sending appropriate copies to the federal district judge in our area. We're sending one to the president of the Senate, the vice president of the United States, and to the National Archives as required by the Electoral Count Act. And here I certify these are true copies of all of these certificates in the proper form and format, telling you everything you need to know so that when you open these votes on the House floor in the joint session and hand them to the vice president and he hands them to the tellers, they can all say with confidence that this appears to be a true and accurate copy, regular in form and content, and indicating that the state of Arizona has cast its electoral votes for the following person, and in this case, Joe Biden, and then everybody writes that down, and then they make the totals, and then, everything is verified at every step along the way. And Trump and his gang were saying, well, what if we just sent the wrong names or the wrong count, or told the vice president that he could say that Biden didn't win Arizona? That was the gist of it. You all know that part, but it's just so astonishing it has to be restated. So where were we? Right. Okay. So the states were going to do that. And then on a date set by the ECA, each state's ascertained electors were required to meet and collect the results of the presidential election, that is, to cast electoral votes based on their state's popular vote and to send their electoral votes along with the state executive certification that they were the state's legitimate electors to the United States Congress to be counted and certified in an official proceeding. And this is why none of the state governors, even Doug Ducey, wanted to go along with Trump's crazy plot, was that you would have to have signed an official document swearing on your authority as governor that the opposite of the truth was true, and send it to the vice president of the United States and the Congress and see it read on C-SPAN and in front of the whole country that you were denying reality and you were lending the authority of the office you held to this effort. And, not only was it not true, but I don't know whether people predicted at that point that this whole thing would fall apart for Trump or whether they thought that he would get away with it. But on the chance that he wasn't going to get away with it, what happens to a governor who swears based on the authority vested in him as governor that the opposite of the truth is true when it all blows up? Presumably you impeach that governor, except of course, a lot of times the states that they were targeting would be ones where the governor was Republican and so was the state legislature, and they'd never vote to convict and remove from office a Republican governor, no matter how egregious his crimes. I think that was the assumption that underlay everything. But it doesn't appear that people like Doug Ducey had a great amount of confidence in that. They didn't want to go through that and even risk that. So they said, no, we're not going to do your thing. Anyway, some places, no state legislatures agreed to go along with this. That was the original plan. Eastman, I think, in his original vision of this thing was that state legislatures, because they were overwhelmingly Republican, would go along with this and would just say, we'll certify the opposite. It doesn't matter to us. We're not going to convict ourselves or our governor of certifying the opposite. And if we can get just one state to go along with this, we'd have a leg to stand on. When it became clear that no state would do this, is where it really got screwy, and where people like Eastman were like, well, you know what? It doesn't even matter. We don't even need the states. There's no such thing as states. There's no such thing as state legislatures. We used to think they were the end-all be-all and they were the most powerful bodies in the world. But screw them. They wouldn't do what we wanted, so we don't even need them. Let's just send fake certificates and see if we can either fool Pence into reading one or convince Pence that he ought to intentionally read one. And then that didn't work either, but we'll get there. We're still on paragraph 9, so we better get moving. Finally, the Constitution and the ECA required that on the 6th of January, following Election Day, Congress meet in a joint session for a certification proceeding presided over by the Vice President of the Senate to count the electoral votes, resolve any objections, that's where they were hoping to intervene in the end, and announce the result, thus certifying the winner of the presidential election as president-elect. This federal government function, again that phrase, from the point of ascertainment to the certification, is foundational to the United States democratic process and until 2021 had operated in a peaceful and orderly manner for more than 130 years. Next up, the manner and means by which this was executed. Paragraph 10, the defendant's conspiracy to impair, obstruct, and defeat the federal government function through dishonesty, fraud, and deceit included the following manner and means. A, the defendant and co-conspirators used knowingly false claims of election fraud to get state legislators and election officials to subvert the legitimate results and change electoral votes for the defendant's opponent, Joe Biden, to electoral votes for the defendant, Donald Trump. That is, on the pretext of baseless fraud claims, the defendant pushed officials in certain states to ignore the popular vote, disenfranchise millions of voters, dismiss legitimate electors, and ultimately cause the ascertainment of and voting by illegitimate electors in favor of the defendant. I mean, you all understand what this means, but I don't know, just to reiterate and to say it again, it's already a travesty of justice that we have an electoral college at all in this country, and that we're all taught that for some reason, like one of the big failings really of the founders was that they just didn't trust people to conduct a popular election and have it work legitimately and elect responsible enough people to this enormously powerful position. And I mean, they were supposed to be the safeguard against putting a populist demagogue in office. And as it turns out, maybe it was not such a great plan after all. But they were saying, well, what if we actually just took these people who were supposed to be the buffer against installing a populist demagogue as president and replaced them with people who were dedicated to the proposition of installing a populist demagogue as president? What if we did that? And normally you would think the answer would be, well, no one would stand for that. And thankfully no one did, which was amazing. But they still said, well, what if we just asked the vice president to do it anyway? I mean, it really hinged on that. And I mean, had the vice president agreed to do it, I don't know how well the argument against it would have gone. I mean, it's obviously ridiculous and fraudulent, but everyone would have stood there and said, I don't know, the president and vice president of the United States both say this is on the up and up. State legislatures are busy saying it's on the up and up, but thankfully no one did. The paragraph B here, the defendant and co-conspirators organized fraudulent slates of electors in 7 targeted states: Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, attempting to mimic the procedures that legitimate electors were supposed to follow under the Constitution and other federal and state laws. This included causing the fraudulent electors to meet on the day appointed by federal law, on which the legitimate electors were to gather and cast their votes, to cast fraudulent votes for the defendant, and sign certificates falsely representing that they were legitimate electors. Now, some fraudulent electors were tricked into participating based on the understanding that their votes would be used only if the defendant succeeded in outcome determinative lawsuits within their state, which the defendant never did. The defendant and co-conspirators then caused these fraudulent electors to transmit their false certificates to the vice president and other government officials to be counted at the certification proceeding on January 6th. We've talked about this at great length on this today and on other days. But in case any of the jargon tricked you here, there was that moment where they said, all right, everybody, let's do the fake electors things. And some just went ahead and did it. But others said, now, wait a second, we're going to be in big trouble if we sign documents, like official documents, that say we're the electors. What you mean, they asked the Trump lawyers, is if you sue and you successfully get a state court in our state, Arizona or whatever it is, to throw out the results, if the legislature wouldn't do it, maybe the courts will. If they'll throw out the results, at the risk of then leaving Arizona without any electoral votes, we will sign instead this other paper that it basically, we will swear in these documents and sign our names to them that we are the proper electors, but you're only going to use this document, right? You're only going to use this document if you win in court first an order saying that the Democratic electors are invalid and not to be counted. And then, just so that there's not, zero electoral votes from Arizona, that's when you'll pull out our paper. Because that's when we would believe that maybe we are the legitimate electors after. We don't know whether your claims are right or wrong. We'd love for them to be right. If a court decides you're wrong, we take it back. If a court decides you're right, then go ahead and tell them that we signed these documents and you'll produce them. And that was the condition that some were smart enough. I mean, it doesn't take it. Like a really smart person says, no, I'm not participating in all of this. But they were smart enough to say, that's my condition. And the Trump lawyer said, yeah, no problem. And then they said, and then things fell apart. At that point, I think Eastman anticipated some activity by some state legislatures. Some state legislatures are so Republican, they will intervene and do this thing. And as Greg was saying, some Republicans just turned out to be kind of on the side of right in the end of all this, even if they arrived at it in weird ways or for weird reasons. And no state legislature was willing to stick its nose in and say yes or no, and no court, therefore, was willing to say, yeah, there's enough here for us to say maybe we hold things up or just invalidate the Democratic electors, period, and substitute the other ones. No one was willing to say that. At that point, Eastman's plan should have been dead, but the reason he finds himself, in this indictment is because they said, you know what? It doesn't matter. It doesn't matter if the state legislatures believe it or act. All we need to do is have Pence say that the electors from Arizona voted for Trump. And if they don't believe him, he can waive this paper. Now, there'll be other people who say, to hell with that, I saw the news. But what will happen is the House of Representatives and the Senate would each have to resolve how they were going to resolve this dispute. There would be an objection, and the Republican House of Representatives and maybe they'd get away with it in the Senate, maybe not, but at least in the House of Representatives, they would vote as on party lines and by state, if necessary, if it came to electing a president because nobody had a majority of the electoral vote as a result of these shenanigans. But they would vote on party lines to say, we'll accept the fake elector slate. No, the state legislature didn't approve it. No court approved it, but it's down to us now. We get to make the decision, and there's no appealing from it if we vote on party lines and just push it through. That was the plan. Eastman never bothered to say, well, if we can't get a court or a state legislature to okay this, we're screwed, just stop. He said we can just make it up. We can just use the power of the majority as absolute power and say the election results are different from what everybody else said they were. Not only were you pre-wrong about the law and the state of the law and the Constitution itself, but you were pre-wrong about the outcome of this particular election. Yes, the numbers were higher on the Biden side, allegedly, but that was all fake, you see. What if it was done by a Jewish space laser? We have to save America and put the opposite results in. And that left a lot of these electors hung out to dry. So where were we here? Now moving on to paragraph C, this is part of the manner and means of the conspiracy. The defendant and co-conspirators attempted to use the power and authority of the Justice Department to conduct sham election crime investigations and to send a letter to the targeted states that falsely claimed that the Justice Department had identified significant concerns that may have impacted the election outcome, that sought to advance the defendant's fraudulent elector plan by using the Justice Department's authority to falsely present the fraudulent electors as valid alternatives to the legitimate electors, and that urged, on behalf of the Justice Department, the targeted states' legislatures to convene to create the opportunity to choose the fraudulent electors over the legitimate electors. Now, nobody bit on that one, but this is an important part of the puzzle that sort of gets glossed over, that they were looking to have Jeff Clark take over. I guess he offered himself as acting attorney general. And he intended to use the Justice Department to push the state legislatures. The U.S. Department of Justice says it would be legitimate for you to intervene at this point and choose to try to substitute Trump electors for Biden electors in your state. D, the defendant and co-conspirators attempted to enlist the vice president to use his ceremonial role at the January 6th certification proceeding to fraudulently alter election results. First, using knowingly false claims of election fraud, the defendant and co-conspirators attempted to convince the vice president to use the defendant's fraudulent electors, reject legitimate electoral votes, and or send legitimate electoral votes to the state legislatures for review rather than counting them. When that failed, on the morning of January 6th, the defendant and co-conspirators repeated knowingly false claims of election fraud to gathered supporters, falsely told them that the vice president had the authority to and might alter the election results, and directed them to the Capitol. In other words, set them on foot to, I would say, the Capitol to obstruct the certification proceeding and exert pressure on the vice president to take the fraudulent actions he had previously refused. This is another place where Eastman's plan falls apart, and it comes down to, well, let's just use force. E. After it became public on the afternoon of January 6th that the vice president would not fraudulently alter the election results, a large and angry crowd, including many individuals whom the defendant had deceived into believing the vice president could and might change the election results, violently attacked the Capitol and halted the proceeding. As violence ensued, the defendant and co-conspirators exploited the disruption by redoubling their efforts to levy false claims of election fraud and convince members of Congress to further delay the certification based on those claims. The defendant's knowledge of the falsity of his election fraud claims comes next. Paragraph 11, the defendant, his co-conspirators, and their agents made knowingly false claims that there had been outcome determinative fraud in the 2020 presidential election. These prolific lies about election fraud included dozens of specific claims that there had been substantial fraud in certain states, such as that large numbers of dead, non-resident, non-citizen, or otherwise ineligible voters had cast ballots, or that voting machines had changed votes for the defendant to votes for Biden. These claims were false, and the defendant knew that they were false. In fact, the defendant was notified repeatedly that his claims were untrue, often by people on whom he relied for candid advice on important matters, and who were best positioned to know the facts. And he deliberately disregarded the truth. For instance, and here there are 5, 6, 7, 8 paragraphs offered of examples of this. The vice president, who personally stood to gain by remaining in office as part of the defendant's ticket and whom the defendant asked to study fraud allegations, told the defendant that he had seen no evidence of outcome determinative fraud. The senior leaders of the Justice Department, appointed by the defendant and responsible for investigating all of this, on multiple occasions told him that various allegations of fraud were unsupported. The Director of National Intelligence told him that it was unfounded. The Department of Homeland Security's Cybersecurity and Infrastructure Security Agency, or CISA, whose existence the defendant signed into law to protect the nation's cybersecurity infrastructure from attack, joined in an official multi-agency statement stating that there was no evidence of any system having been compromised, and that declaring the 2020 election, again, remember this, the most secure in American history. Now, days later, after the CISA director, whom the defendant had appointed, announced publicly that the election security experts were in agreement on this, the defendant fired him. Section E here are senior White House attorneys selected by the defendant to provide him candid advice, informed the defendant that there was no evidence of outcome determinative election fraud, and told him that his presidency would end on Inauguration Day in 2021. There were senior staffers of the defendant's 2020 re-election campaign, whose sole mission was the defendant's re-election, telling him nonetheless that it was all untrue. And state legislators and officials, many of whom were defendant's political allies and had voted for him and wanted him to be reelected, repeatedly informed the defendant that his claims of fraud in their states were unsubstantiated or false, and resisted his pressure to act based upon them. And lastly, state and federal courts, the neutral arbiters responsible for ensuring the fair and even-handed administration of election laws, rejected every outcome determinative post-election lawsuit filed by the defendant, his co-conspirators, and allies, providing the defendant real-time notice that his allegations were meritless. But going into this, they were hopeful that they could just say, well, some Trump-appointed judge somewhere will say the opposite, and we'll just go with that. But no one would do it. The defendant widely disseminated his false claims of election fraud for months, despite the fact that he knew and in many cases had been informed directly that they were not true. The defendant's knowingly false statements were integral to his criminal plans to defeat the federal government function, obstruct the certification, and interfere with others' right to vote and have their votes counted. He made these knowingly false claims through the post-election time period, including those below that he made immediately before the attack on the Capitol on January 6th. And you've heard most of these, of course. There was the defendant saying that more than 10,000 dead voters had voted in Georgia, that 205,000 more votes than voters who existed were counted in Pennsylvania, the suspicious vote dump in Detroit, Michigan, tens of thousands of double votes and other voter fraud in Nevada, 30,000 non-citizens had voted in Arizona, and finally that the voting machines were switching votes from him to Biden, all of which in each of these small paragraphs here, it is noted who told President Trump that that stuff was false or unsubstantiated. And he should have known it. I mean, he did know it. That's the point. The criminal agreement and acts to effect the object of the conspiracy is next. The defendant's use of deceit to get state officials to subvert the legitimate election results and change electoral votes. Beginning in paragraph 13, shortly after Election Day, which fell on November 3rd, 2020, the defendant launched his criminal scheme. On November 13th, the defendant's campaign attorneys, but also his criminal attorneys, as it turns out later on, conceded in court that he had lost the vote count in the state of Arizona. Okay, his criminal defense attorneys never conceded that. His campaign attorneys conceded loss of Arizona, meaning based on the assessment of defendant's campaign advisors had given him a week earlier, the defendant had lost the election. So, the next day, the 14th, that's where the conspiracy is alleged to begin, right? The defendant turned to co-conspirator 1, Rudy, whom he announced would spearhead his efforts going forward to challenge the election results. From that point on, the defendant and his co-conspirators executed a strategy to use knowing deceit in their targeted states to impair, obstruct, and defeat the federal government function as described below, or including as described below, in Arizona. I'm sure we'll only get through Arizona today. On November 13th, 2020, the defendant had a conversation with his campaign manager who informed him that a claim that had been circulating that a substantial number of non-citizens had voted in Arizona was false. But he ignored it beginning on the 14th of November. On November 22nd, 8 days before Arizona's governor certified the ascertainment of the state's legitimate electors based on the popular vote, the defendant and co-conspirator 1, Rudy, called the Speaker of the Arizona House of Representatives and made knowingly false claims of election fraud aimed at interfering with the ascertainment of and voting by Arizona's electors as follows. A, the defendant and co-conspirator 1 falsely asserted, among other things, that a substantial number of non-citizens, non-residents, and dead people had fraudulently voted in Arizona. The Arizona House Speaker asked Rudy for evidence of these claims, which Rudy did not have, but claimed he would provide. By the way, Rudy never did so. It says right here in the paragraph A. In B, the defendant and co-conspirator 1, Rudy, asked the Arizona House Speaker to call the legislature into session and hold a hearing based on their claims of election fraud. Well, the Arizona House Speaker refused, stating that doing so would require a 2/3 vote of its members, and he would not allow it without any actual evidence of fraud. And C, the defendant and co-conspirator 1, Rudy, asked the Arizona House Speaker to use the legislature to circumvent the process by which legitimate electors would be ascertained for Biden based on the popular vote and simply replace those electors with a new slate for the defendant. The Arizona House Speaker refused, responding that the suggestion was beyond anything he had ever heard or thought of as something within his authority. Like actually, serious in all of this. Paragraph 16, on December 1st, co-conspirator 1 met with the Arizona House Speaker when the Arizona House Speaker again asked him for evidence for the outcome determinative election fraud that he and the defendant had been claiming. Rudy, co-conspirator 1, responded with words to the effect of, how do you like this? We don't have the evidence, but we have a lot of theories. You can imagine him saying, we don't have the evidence, but we have a lot of theories. Give me another drink. Paragraph 17, equally astonishing here. We better play our outro music. On December 4th, the Arizona House Speaker issued a public statement that said, in part, look, no election's perfect. If there were evidence of illegal votes and improper count, then Arizona law provides a process to contest the election, a lawsuit. But the law does not authorize the legislature to reverse the results of an election. As a conservative Republican, I don't like the results of the presidential election. I voted for President Trump and I worked hard to reelect him, but I cannot and will not entertain a suggestion that we violate current law to change the outcome of a certified election. I and my fellow legislators swore an oath to support the U.S. Constitution and the Constitution and laws of the state of Arizona. It would violate that oath, the basic principles of Republican government, and the rule of law if we attempted to nullify the people's vote based on unsupported theories of fraud. Under the laws that we wrote and voted upon, Arizona voters chose who wins, and our system requires that their choice be respected. I know it's kind of like boilerplate stuff, but that's because it's bedrock foundational democracy. Of course he has to say this, but the point of this indictment and this section of the indictment is that in state after state after state, that's exactly what happened. They were pressured to just say, to hell with the law, to hell with the reality, to hell with everything. Just say the opposite. And I don't even know if this indictment gets to that part where Trump is alleged to have said, just allege fraud and leave it to us, the Republicans, to fix this thing. Because that's important too.
You've been listening to Kagro in the morning with David Waldman.
Anyway, look, that's the bottom line of it. The Arizona House Speaker does it right there. And he says, look, we're bound by our oath to defend the Constitution of our state and of our country, and he was asking us to undo that in several states. That ought to be indictable crime. Let's hope it gets tried quickly. We'll see you to talk about it more tomorrow.